This is directly from the Seventh Circuit. This is a broadening occurrence definition. Illinois courts have determined that damage to a construction project that occurs as a result of a construction defect does not constitute an accident or occurrence because it is the natural and ordinary consequences of faulty construction. Again, faulty workmanship, bad work is not an accident. Court went on, didn't stop there. But this does not foreclose defendants' arguments that the alleged damage could fall within the policy's coverage and therefore, at a minimum, trigger its duty to defend. Under Illinois law, negligently performed work or defective work can rise to an occurrence under a CGL policy. This is true, and this is the key takeaway from the Westfield National Decorating case. This is true where, as in the case here, the policy defines an occurrence to include not only an accident, but also continuous or repeated exposure to conditions. That quoted language right there. Continuous or repeated exposure to conditions. Here, the underlying complaint alleges that National Decorating was negligent. This is sufficient to satisfy the policy's occurrence requirement when determining there is a duty to defend at this juncture in the litigation. And defense costs and expenses can be very, very high in these construction cases, the underlying case that was going on. You have experts involved. The litigation can be prolonged. So that duty to defend, even for James McHugh, the general contractor and the owner, 200 North Jefferson, even for them to get that duty to defend triggered and save on those defense costs is a huge win on their part. And again, you'll see that the standard is very liberal for the court. It's going to search policy language, search contracts in an effort to find coverage, not a forfeiture of coverage. So your policy language for the insurers out there has to be very tight, it has to be very specific, it has to be very explicit. It wasn't here. And again, the court focused on continuous or repeated exposure to conditions, which was included in the definition of occurrence. So that's what I want you to take away from the Westfield case of the Seventh Circuit.